Welcome to our constitutional law class. So previously we have discussed the concept of constitutionalism, and we explained that to essentially mean the idea that there's a need for restraint, there's a need for limitations to be placed on those who are endowed with governmental powers so that the liberty of the citizenry will be safeguarded against arbitrariness, against unjustifiable interference. And to do that, we noted that it's necessary for us to have at least three forms of limitations on government. So we talk about substantive constitutionalism or substantive limitation. That is where those who are endowed with powers of governance are specifically prevented from doing certain things so as not to undermine the liberty of the citizenry. Then we also talk about procedural constitutionalism or procedural limitation, where you have been given the power to act, but then you are required to exercise the power in a particular manner or follow a particular procedure. And if you don't follow that procedure, then the power cannot lawfully be said to have been exercised. So that is procedural constitutionalism. Then we also talk about institutional constitutionalism, constitutional limitation, which simply means that various institutions may have to cooperate before certain powers or authorities can be exercised. And we made the point that we have inexhaustive mechanisms of achieving constitutionalism, of effectuating the idea that restraint should be placed on the wheels of governance. Restraint should be placed on those who exercise governmental authority. Nevertheless, we mentioned that there are certain pillars or certain well-known mechanisms for ensuring constitutionalism. So among other things, you talk about separation of powers and checks and balances. You talk about having a robust regime of protection of fundamental human rights and freedoms. We talk about having a proactive civil society, and so on and so forth. So tonight, we would like to discuss separation of powers as a concept and how it is deployed in order to advance constitutionalism. Remember, we have already noted that constitutionalism is not an event, so to speak. It's not something which is just there. And we even said that if we look at the literature, commentators or scholars will tell us that constitutionalism is more, is an ideal which we are working towards, or an aspiration, is a spectrum, so that at every point in time, we can say that whether a particular country has made significant progress on constitutionalism or not. So that was the point that we made. So if that is so, when we say separation of powers, what is it? What does it mean? Well, in this class, we are going to unpack conceptually what separation of powers means, and also try to understand how this concept of separation of powers has evolved over the ages, and try to also understand its underlying philosophical arguments. And finally, we will look at how the concept of separation of powers is reflected in some constitutional system, the American system, and more importantly, our own Ghana constitutional arrangement. How is the concept of separation of powers reflected? Have we followed what we call the strict version of separation of powers, or have we adopted the flexible version? So these are the matters we are going to be discussing in this particular class. Yeah, so at the outset, we need to remember the point which we have already made, that the doctrine, of course, there's a debate as to whether it's even a doctrine or concept, but I wouldn't like us to get ourselves involved in the doctrine concept debate. It suffices just to understand what constitute what we call separation of powers. So we'll be using concept and doctrine interchangeably, but essentially it shouldn't affect what we want to learn. So separation of powers is a foundational element to modern democracies, for the reason that it safeguards against concentration of power in any single branch of government. I mean, at the elementary stage, we all remember that when we talk about government, if for nothing at all, we know the three arms of our government. We know the legislature, we know the executive, we know the judiciary. So fundamentally, there is that recognition that governmental power should not be concentrated in any single branch, should not be concentrated in any single individual, to speak. So separation, we have separation of functions, as it were, and in which case we split governmental power among three branches, as I have indicated. So the executive, we know, is responsible for implementation or carrying out laws and then the policies. The legislature is responsible for the function of making laws and exercising oversight. And the judiciary is responsible for enforcing the law, to speak. So therefore, each of the branches of government operates within specific constitutionally defined limits. And that ideally ensures that no branch wields unchecked power. So each branch serves as a check on the other. So that is the idea. Each branch serves as the check on the other. And why is that important? Why is it important to avoid concentration of powers of government in just one branch or one individual? Of course, where you have concentration of powers of governance in just an individual or one organ, you are sure to have tyranny or to have authoritarianism, authoritarian rule. And that will certainly be counterproductive to the freedom and liberty of the citizenry. So where you spread power across different institutions, across different organs with distinct responsibilities, then separation of powers is at work, and that provides a structural mechanism to prevent abuses and protect individual liberty. So that is the basic idea. So by way of our introduction, that is what we should keep in mind. So what is the philosophical underpinning? In other words, if you look at scholars who have come before us, especially philosophers who try to reflect on various things and try to understand or make sense of things that are, with respect to governance in relation to what we call separation of powers, what are some of the ideas which have come out from the reflection of these thinkers over the years? So that is what we want to explore. And at the very outset, we would like to make the point that the principle of separating governmental functions, that is, avoiding concentration of governmental functions in one entity or in one individual, can be traced back to the ancient Greeks and also the Roman Empire. And there, thinkers observed the dangers of concentrated power, the dangers of putting all power in the hands of one person. So if you take Aristotle, for example, he did various work, one of his work called the Politis. Aristotle, in his work, Politis, will discuss different governmental functions and made argument for a system where powers were distributed across varied bodies in order to prevent abuse. So that in itself was recognition by philosophers like Aristotle that yes, it is dangerous to just leave the whole gamut of governance in the hands of one person or institution, as it were. But the point needs to be made that the theory of separation of powers, as we understand it today, or as we recognize it today, was substantially or largely refined by Enlightenment scholars. There was a period in European history that we call the period of Enlightenment. That came after what we call the Renaissance period. And during the Enlightenment period, scholars had a very probing mind, and they subjected everything to interrogation. So that is where critical thinking developed effectively. And some of the Enlightenment scholars included the social contractarian, John Locke, and also the respected philosopher, Baron de Montesquieu. And the ideas of these scholars have shaped our modern understanding of what we call separation of powers. So let's look at what John Locke contributed in illuminating our understanding, appreciation of separation of powers. John Locke, as I have said, was a social contractarian, which we made reference to when we were discussing the philosophical underpinning of constitutionalism, if you remember. And I made the point that the social contractarians, or those who propound the social contract, they attempt to explain why we have the state, why people should obey the state, or why the state can exercise some authority over the citizenry and expect the citizenry to obey the laws and institutions of the state. So that is basically what the social contract theory attempts to explain. Now, that is not what we are talking about, but John Locke, who falls within those category of scholars, propounded the work which is known as the Second Treatise of Government, way back in the 17th century. And in his seminal work, the Second Treatise of Government, or the Two Treatises of Government, that is how some will put it, John Locke introduced the idea of separating powers as a means to ensure accountability and limit the potential for governmental abuse. So he was merely concerned with the executive and legislative functions. And John Locke believed that these functions, that is the legislative function, executive function, should be separated, should not be given to one institution or one body or entity. And he considered separation of these two functions to be necessary so as to avoid conflict of interest and prevent those who make laws from also enforcing them as it were. So his argument was very straightforward, and it was that lawmakers should not hold enforcement power, as it will enable them to exempt themselves from the laws they pass. And that will create a self-serving and possibly a tyrannical system. So if, let's look at what happened recently in our parliament, okay? So just imagine if parliament had the final authority to make pronouncement as to what the proper constitutional position is on situations or matters. Just imagine where we have been. I'm still waiting to get the reasoned judgment of the Supreme Court in the case involving the Speaker of Parliament and then the, what is the name? The Majority Leader, Afena Markin, and then the Attorney General, regarding the 4 MPs who were said to have lost their seat by reason of having crossed the carpet. Yeah, so Locke identified 3 branches of governmental power. So he identified the legislative, the executive, and what he called the federative power. And he associated the federative power with foreign relations, and in a very ambiguous fashion also put it under the executive. Now, for John Locke, the executive power was supreme because in his thinking, it represented the will of the people. Because we have a representative of the people constituting the Legislative Assembly of Parliament. And that is why he considered the legislative power to be supreme. But he understood the executive role to implement laws rather than create them. And he made the argument that legislators should convene only when necessary to make laws and then disband to avoid the temptation of overreaching their mandate. So in John Locke's thinking, the work of the legislature was supposed to be ad hoc. You come and make a laws and then you will leave. So just a second. Yeah, of course, if you look at the modern practice, contrary to what John Locke suggested, our lawmakers are more or less like a full-time workers, and they are not no part-time lawmakers, as John Locke suggested. Of course, his concern was that if the lawmakers could be working on, if you like, ad hoc or seasonal basis, then you avoid the risk of entrenching power or concentrating power. But you notice that much as that was a good suggestion, the reality of modern society sort of defeats the logic of John Locke's suggestion that lawmakers should largely be part-timers or ad hoc, as it were. Now, we also have Baron de Montesquieu, the French political philosopher, and he expanded upon John Locke's ideas. He did the work, The Spirit of the Laws, or Esprit de Loi. Those who know French, he was a French scholar. And despite the fact that Montesquieu was a French philosopher, he had observed the English constitutional system for a long time when he visited England. Of course, later on in his writing, he will confess that he did not have a perfect understanding of the entire working of the English constitutional system. Nevertheless, whatever he observed or he perceived regarding the English constitutional system is what influenced the development of his ideas with respect to separation of powers. So Montesquieu saw the English constitutional system with respect to the checks and balances as the ideal safeguard against tyranny, because he believed that the English system effectively divided government power among different institutions and created an internal check on authority. Well, if you look at the English constitutional system, it's not changed much. You have like the parliamentary system, the majority party will have its leader invited by the monarch, the king or the queen, depending upon whether it's a male or female, to form the government. And then we have like the courts, which are developed from the common law era until now. So in Montesquieu's work, he also advocated for three distinct branches along the lines of John Locke, but he talked about the legislative branch. Yes, sir. And apart from the legislative branch, he also talked about the executive and then the judiciary. And Montesquieu made the point that liberty of the individual or the citizen will be lost if any single body or individual held two or more of these powers simultaneously. That is, he's talking about the legislative, he's talking about the judiciary, he's talking about the executive, that it is not good for more than one, as it were, of one of these powers to be vested in an individual or entity. And he's quoted in the literature to have made this statement that the Montesquieu speaking, quote, "When the legislative and executive powers are united in the same person or in the same body of magistrates, there can be no liberty, because apprehensions may arise lest the same monarch or senate should enact tyrannical laws to execute them in a tyrannical manner," unquote. So just reinforcing the point we have attributed to Montesquieu, that it is not safe for more than one of the three functions, lawmaking function, legislative, implementation or execution function, executive. And then the enforcement function, that is the judiciary, to be vested in one individual. So if you like, using what Ghanaians we are used to, we can say that Montesquieu would rather prefer one institution, one governmental function. One governmental function, one institution or organ, rather than one organ or institution having two governmental functions. So Montesquieu argued that the separation he had advocated was not only about dividing functions, that is, have separate lawmaking function, have law enforcement function, law implementation function, as it were. But he was concerned about creating institutional interdependence. So Montesquieu envisioned a system where each branch of government could operate independently, but was simultaneously accountable to and interlock with others. So the executive should be able to operate independently. At the same time, it should have some accountable relationship. It should have some interface with the other branches. And the same thing applies to the legislature. The legislature should be able to work independently, but at the same time, it should have some accountability and some interface with the other branches. And the judiciary too should have independence, but it should also have some accountability or some interface with the other branches. So that is the teaching by Baron de Montesquieu. So Montesquieu ultimately introduced the idea that a balanced tripartite division could serve as a check or counterweight against the misuse of power. So the tripartite here simply refers to the three functions: the legislative, the executive, the judiciary. And we say that, yes, if you have these three functions and also have them vested in different institutions, they would enable a function or organ that may have the tendency or the disposition to abuse its or misuse its power against liberty of the individual to be checked by the other. So that is the point that he was talking about. And that is the concept of what you call the mutual accountability, or popularly known as checks and balances. So checks and balances, just the idea that each organ would hold the other to accountability. So in modern times, when we are talking about the doctrine or the concept of separation of powers, it is very much linked with the idea of checks and balances, the idea of mutual accountability among the tripartite arms of governance, the executive, the legislature, and then the judiciary, as it were. Any question before I continue? Because I have locked the mic, if you want to ask a question, you need to raise up your hand, and then I will release the mic. Otherwise, I'll continue. Okay, so let's take Sabato. Yes. Sabato, please go ahead.
Yeah, hello.
Yes.
Okay, I'm looking at a central theme in Montesquieu's theory, where he speaks about power not being concentrated in one arm of government, essentially where he speaks about one person not holding powers of two organs, for instance. I am asking this question in relation to Article 6011 and the ruling of the Supreme Court in Asari versus Attorney General, where Article 6011 says that in the where the president and the vice president are unable to perform the functions of state, the Speaker of Parliament is sworn in. The Speaker of Parliament being the head of the legislature and at the same time being given the powers of the president when he's sworn in as acting president. How does this arrangement in the Constitution fare with Montesquieu's theory?
All right, thank you, Sabato. Good. So in the course of this lecture, we will be discussing what we call the two contrasting perspectives on separation of powers from the U.S. Case known as the Steel Caesar case, or the Youngstown Steel Caesar case. That's as Blacks and that's as Jackson's view, and we come to appreciate that there is emerging consensus, especially of those who subscribe to the flexible view or flexible version of separation of powers, that in order for government to work pragmatically, it is necessary not to advocate for rigid or strict understanding of separation of power. So coming back to your, Asari, the Supreme Court, and then the constitutional position that where both the president and then the vice president are unable or they're absent, then the speaker should assume the role and the function of the president, whether that is not counterproductive to Montesquieu's concern that there's a need to avoid concentration of a more than one function in an entity. Now, what I would like to bring to your attention is that constitutional position is a unique compromise for a brief period. Of course, if you read the Travaux Préparatoires, if you read the Committee of Experts report, the proceedings of deliberations of the Constituent Assembly, and all the preparatory documents which preceded the final test of the 1992 Constitution, you appreciate that the framers of the Constitution, in their wisdom, envisage that a situation where the president and the vice president will be both unable to carry out their function will by and large not be a long period to start with. And again, there is also unwritten understanding, unwritten law, unwritten principle that usually anywhere, not only in the government, anywhere, even in switching companies, when you have been given a temporal acting role, it is not expected that, apart from very minor routine things which do not require major decision or initiative, you do anything. So all those are some of the things which influence the way and manner that provision is crafted. So yes, the speaker will act as the president, but it is not expected that that will go on for a long time. And it's also not expected that the speaker as the acting president will take, if you like, major or substantial initiative or policy choices, as it were. Even in practical, when it comes to companies, maybe you're acting, your boss is not that you're acting for a brief period. It's not expected that you do anything major, as it were. So we have talked about the significance of separation of powers in preventing tyranny, preventing authoritarianism, and ensuring liberty. I mean, that is the whole point of trying to ensure that one branch or one organ of government does not dominate or undermine the others. So once you have the clear boundaries for each of the branches, each of the organs, then you have provided a veritable constitutional defense mechanism against any particular organ or institution becoming authoritarian, and for that matter, tyrannical, which would undermine the liberty of the individual, as it were. So, for example, if you have an independent judiciary, it can prevent the executive from overstepping its authority. And we see this all the time. For example, when it comes to the Mr. Zomlovo's issue, you see how the Supreme Court actually disagree with the executive regarding how his appointment was more or less terminated, as it were. And not only that, we can cite so many examples. You remember the 31st December case, the attempt to use the state resources by the then government to celebrate coup d'etat. And I also remember the IG NPP versus that public order case, how the executive and the legislature were actually told off, so to speak, by the judiciary, by the Supreme Court, regarding how certain existing law or certain laws could not be tolerated as they undermine the freedom of the individual, especially the freedom of assembly, demonstration, and procession. In the same way, the executive also can have veto power or some enforcement prerogative to restrain legislative excesses or judicial overreach. So let's take the LGBT or the proper human sexual values bill, which has been passed by Parliament. You see the stalemate that we've had. I mean, quite apart from the fact that the matter has been taken up in the Supreme Court, by someone, even without going to the Supreme Court, if you look at Article 106 of the Constitution, the president who have actually, stated the reasons informing his decision not to assent to the bill and confer with the Council of State, and then the Council of State will come back, and then the matter will go back to Parliament, unless the Parliament will get the 2/3 majority of all MPs, so to speak, to override that executive veto. But the mere fact that that mechanism is there is an evidence that no single organ, no single branch can be overpowerful to the extent that it has immune itself from the controlling accountability from other organs or other branches. So that is the point that we are making. Yes, Nafisatu. Yes.
Okay. Your Lordship, and when you were explaining the question that Sabato asked, you just by saying that it's as a result of unique compromise for a brief period. However, we have a situation that I think it is not for a brief period, but for a perpetual period, where in this case we have some members of parliament serving as ministers of state. Doesn't that defeat the purpose of separation of powers?
Oh, right. Good. So, that is why I made the point. Yes, if you take our constitution in Article 78 and other provisions that majority of the ministers should be members of parliament. Yeah, so that brings up the issue. Is that not undermining the teaching of Montesquieu that we should avoid concentration of more than one function in one institution or one person? Well, as I have indicated in my attempt to respond to Sabato's question, we have what you call the strict understanding and then a flexible understanding of separation of powers. If you are subscribing to the strict or the rigid, the separation of powers in its puritanical or pristine sense, then you are right in saying that it is not conceptually appropriate for a minister of state to at the same time be a member of what? Parliament. On the other hand, if you accommodate the flexible version of separation of powers, then you will begin to appreciate how you can have a lawmaker at the same time serving in the executive without necessarily compromising what separation of powers seeks to achieve. And mind you, we have made the point that separation of powers go hand in hand with mutual accountability known as checks and balances. So you ask yourself, in our system, for example, where the Constitution has stated that majority of ministers should come from parliament, do we have adequate safeguard mechanism with respect to checks and balances to ensure that despite the fact of having lawmakers also being part of the executive, we are not going to have a situation where they become overpowerful and then they will undermine the liberty of the citizen. And certainly, if you look at even our country, Ghana, if you look at like, the reality, if you go to parliament, if somebody were to do like a research, the past 30 years since 1993, when the Constitution came into force, we've always had that. So can we say that the fact that, of course, I gave you Nona Dr. Esquivel's Asante's public lecture on your platform, and he expressed, concern that maybe one of the weaknesses of Parliament in exercising effective oversight is the fact that some members of Parliament are at the same time ministers. And if you go to Parliament, we have what you call the standing committees of Parliament. And these standing committees of Parliament, they are composed or constituted by members of Parliament. And these members of Parliament, some are also ministers. So where, for example, let's say that the Public Accounts Committee, for example, invites maybe, let's say, the Ministry of Energy to come and justify certain expenditures and so on. The minister coming, he's also an MP. And even if he's not a member of that, public accounts committee, he probably serves on other committees with some of the members serving in this committee. So there's that kind of a camaraderie, there's that kind of a collegiality there. Yeah, so those are some of like the practical challenges. Now, in terms of the structural division, which we've been discussing, that is the fact that we should not only have the differentiation in functions, like just having the legislative function, the executive function, the judiciary function, but you must also have the differentiation in institutions regarding these functions. We can trace their emergence to some of like the most, what you call like modern democracies, like the US Constitution, for example. Now, if you study American constitutional law, we have a certain literature which we call the Federalist Papers. The Federalist Papers are a collection of position papers submitted by various people who made input regarding the drafting of the US Constitution. And James Madison, in the Federalist Papers, for example, argued that a well-designed government must internally divide power to prevent tyranny. Now, that argument by Madison is an endorsement of Montesquieu's core argument. And how did James Madison put it? Let's quote Madison's in his own words from the Federalist Papers. So this is what Madison said, quote, "The accumulation of all powers, legislative, executive, and judiciary, in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny." Unquote. So James Madison was putting the teaching of Baron de Montesquieu, if you like, in other words, as it were. Because what he has said is essentially what Montesquieu also taught us. So, Madison is just echoing Montesquieu's principles that it is important to divide power. And not just divide it, you must also work an arrangement where power will check power. So you have balance. So the key takeaway is that the doctrine or the concept of separation of powers has a very long history and philosophical conviction. And that is what has shaped modern democracies in their adoption of separation of powers. And separation of powers is not simply a rigid constitutional formula. No, so just for some of the questions that you brought up, the questions tend to suggest that yes, separation of powers is a very rigid formula. It's like if we take the three functions of government, it's like they are in three separate streams or channels and their authors do not meet whatsoever. No, we should rather see separation of powers as a dynamic model for structuring government that allows for the coexistence of freedom and order. So that is the bottom line. So coexistence of freedom and order. You want to avoid consideration of parts of governance in one institution. For what reason? So as to avoid one institution or one organ becoming too powerful. And then when one institution is too powerful, what next? That would undermine all freedoms and liberties. And that is what you want to avoid. So let us keep that in mind. So theoretically, we can say that two main theories have actually evolved over the years to guide our understanding of what we call separation of powers. We can talk about what we call like the classical theory. The classical theory, that is a very original understanding of separation of powers, at least going by the thinking of John Locke, Montesquieu, as you have seen. And the classical theory is looking at the strict division between the branches. And of course, most of us, when you talk about separation of powers, that is what we'll be thinking, the classical one. Yes, we have strict executive functions in the executive, no interaction, communication whatsoever with the other branches. The judiciary, no interaction whatsoever with the other branches. The legislature, no interaction whatsoever with the other branches. So that is the, if you like, the classical theory. And then we also have what we call the modified theory, if you like. The modified theory, that is where we're not just looking at strict division, but you're also looking at a division which also has got what you call like the chess and what? Balances. A division which also allow for interdependence among the branches. So that is what we should keep in mind. And the classical theory, as I said, is a reflection of what the Montesquieu has actually taught us. And because the classical theory emphasizes strict separation, so we have the legislative branch, which is going to be strictly responsible for making laws and should be independent to ensure that laws reflect the will of the people. So if you look at Ghana, for example, can we say that with respect to lawmaking, the classical theory is working? Certainly not. And as we come to discuss separation of powers reflected in the Constitution, you notice when it comes to lawmaking, for example, even when we were discussing constitutional constitutionalism, we came across the point that when it comes to lawmaking, any law which is going to have financial burden on the state, the law must be initiated by what? By the executive. So despite the fact that the legislature has the power to make laws, they themselves cannot just make any laws at all. For the past 31 years that we've had the civil constitutional democracy, I stand to be corrected, but just off the cuff, I do not think that the number of what we call like the private members, but that is a bill which are just emanated from parliament on their own without coming from the executive. I don't think you can get up to 5. If you're able to get 5, which did not come from the government of the day, that will be a great achievement. I don't think we may go more than 5, as it was since 1993. Then, in the classical theory, talking about the strict separation, that the executive branch would just enforce the laws made by the legislator. but they should not have the power to make or interpret the laws, as this will enable it to bypass legal limitations. But in reality, the executive, is that what they do? Are there not times that we see, for example, the Attorney General writing opinion for the government regarding legality of certain measures that the government want to take or not, without necessarily even going to court? When it came to the domestic exchange and I think some other bond arrangements, we witnessed this. So, is that really conforming to what the classical theory, the strict separation, strict division is talking about? Certainly not. And then another classical theory too, we have the judicial branch, the judiciary, which will interpret the laws and ensure that they are applied fairly and consistently, but should not engage in lawmaking or law enforcement functions. Now, if you look at our Constitution, we have what we call the Rules of Court Committee. The Rules of Court Committee actually make the various procedural rules, the tribal rules, which govern how the court operates. So the Supreme Court rules CI 16, the Court of Appeal rules CI 19, the High Court rules CI 47, the District Court rules CI 59. All these were made by sub-agencies of the judiciary, so to speak. Yeah, so the classical theory, which we have stated is what the Montesquieu taught us, is talking about a system of pure separation, if you like. Pure separation, where each branch's powers and functions are distinct with no overlap. So this rigidity, that is the strict separation, in theory, can safeguard liberty. That is true. But in practice, it's not workable. It's not workable in the sense that it leaves limited room for collaboration or necessary oversight. Just imagine if we're going by this so-called pure separation, the government machinery will not be able to work meaningfully, so to speak. So, a purely classical separation could lead to inefficiency, operational inefficiency, or governmental deadlock, particularly in situations that require coordination across branches. I'll give you an example. Let's say Ghana. Now, governments in Ghana provide very interesting material for constitutional law discussion and research. If we take Ghana, for example, currently, we've had a sort of like a deadlock or stalemate in Parliament. Parliament needs to sit so as to get certain bills which the executive need to govern the country pass. But here is the case. Parliament is not sitting. And the executive cannot just contract certain loans, cannot just take certain monies from the consolidated fund, contingency fund, and the various funds. Because even where you have a budget, you need various appropriation bill to take money from the various funds of the state. Parliament must pass a law which will authorize the executive to do that. So, where the executive, for example, at the Parliament, for example, is not sitting, as we currently have, the executive cannot function meaningfully. There are certain appointments which are initiated by the executive, but it needs prior approval of Parliament before the appointment can be completed. I give you an example, like nominees to be appointed to the Supreme Court. After getting advice of Judicial Council of State, the president must get approval from the Parliament. So where Parliament does not sit to approve, despite the fact that the executive has the powers of appointment, it will not be able to meaningfully deploy or utilize that power. Yeah, so we have seen that adherence to the classical theory is not practical, or is not workable, or it will undermine operational efficiency in government. So we have what we call the modified theory of separation of powers, checks and balances, as is often called. And it emerged as a response to address the impracticalities of rigid separation. So you take scholars like James Madison, we've quoted already his Federalist paper, and he will acknowledge the importance of separation, but will maintain that there's a need for some level of interdependence and mutual oversight among branches of government. And that is the only way you can have effective governance and prevent abuses of power. So that is, I think, a very sensible compromise. So under the modified theory, we have what we call the overlap and what? Interaction. Each branch has powers that overlap or intersect with the functions of others. We can give so many illustrations. Let me give you illustration. You talk about lawmaking, for example. Yes, a parliament has the power to make a law, but the law, to a large extent, must be initiated by the executive, especially if it has financial implication. Or even quite apart from that, when Parliament has exercised its power to make a law, the law must be assented to by the president. Without the presidential assent, the law cannot become law, so to speak. And not only that, you take the judiciary, if for nothing at all, opinion marking against the Attorney General and the Speaker of Parliament. A very recent decision of the Supreme Court that the judiciary, for that matter, the Supreme Court, exercises the oversight over even over the legislature, over Parliament. Yes, the court will not dictate how Parliament should work, and people will cite the jurisprudence from 24 versus Attorney General, that what happens in Parliament is like a closed book. Nevertheless, where there is uncertainty regarding the proper meaning, the proper understanding of the Constitution vis-a-vis the work of Parliament, Supreme Court, being the body clothed with exclusive jurisdiction of mandate to make authoritative pronouncement on constitutionality, will come in to determine whether a particular meaning, which is being assigned by Parliament to a provision of the Constitution vis-a-vis developments in Parliament, is what should be the proper understanding of the Constitution or not. So there's that kind of overlap and interaction, as it were. And of course, under the modified theory, we have mutual accountability. So no branch operates in complete isolation, and each branch is subject to constraints imposed by the others. We take even the judiciary. When it comes to, that's why the fact that I talk about independence of the judiciary. When the judiciary, they have their budgets. The budgets will have to be defended before the parliament. The monies under the budget will have to be released by the executive. And all those things constitute some of the various forms of what? Mutual accountability, so to speak. Again, under the modified classical theory that we'll be discussing, it prevents deadlock and abuse because of the interdependence that we have talked about. But just imagine if we do not have the interdependence in any way, the wheels of government would always be in a stalemate and nothing will get done as it were. So this modified version has been applied in various constitutions. It's now 9:17. So I will pause here. We certainly cannot finish tonight. We have one more class and then we finish with the separation of powers. And then we'll discuss rule of law and then the judicial review, and it should be ending the semester. Yeah, so if there are, I'll take one or two questions before we end for the night. You can put up your hand.